Have you applied for a protection order and now you have to attend a hearing? Are you anxious about it? Hi, I'm Simon Dippenaar and I'm a family attorney. If you're threatened by your partner, you probably already feel vulnerable and unsafe. Going to court may seem daunting, but you don't need to feel afraid. Knowing what to expect may ease your nervousness, so I'll explain exactly what goes on in a protection order hearing in a South African court. Protection order hearings are civil proceedings designed to provide swift, effective relief from abuse and harassment. You can obtain a protection order prohibiting your abuser from coming near you or contacting you. The Domestic Violence Act, the DVA, allows for interim orders to be granted without the need for you to be present, if urgent, followed by a return date for a final order hearing. To grant an interim order, the court must be satisfied there is sufficient evidence of domestic violence and immediate protection is necessary. Now, the Protection from Harassment Act, the PHA, provides similar relief for victims of harassment regardless of any domestic relationship. It's a procedure that closely mirrors the DVA in that you can apply for an interim protection order if there's evidence of harassment and urgent harm. Whether under the DVA or PHA, an interim order offers immediate but temporary protection, and the other party is given a return date to appear in court and you argue why the order should not be made final. Applications are usually made by sworn affidavit submitted at the magistrate's court. The initial application is usually decided ex parte. This means only the applicant's side is heard. You file a form and affidavit detailing the incidents of violence or harassment, attaching any evidence such as photos of injuries. At this stage, the court must, as soon as reasonably possible, consider the application and may consider additional evidence such as affidavits from witnesses. Because your abuser isn't present at an ex parte hearing to give their version of events, the law imposes a duty of utmost good faith on you. You must fully disclose all material facts, even those that might be unfavorable. Failure to reveal important information can lead to the interim order being overturned at the return hearing. If the magistrate agrees you are at risk of imminent harm, an interim protection order is issued immediately. This order is served on the respondent together with the notice of the return date for a full hearing. If the respondent breaches the order, they can be arrested. On the return date, the court will decide whether to make the protection order final. Both parties have the right to be heard at this hearing. If your abuser does not appear on the return date, the court may proceed in their absence. Under the DVA, if the case started with an interim order and the respondent fails to show up, the court must issue a final protection order if it is satisfied that the interim evidence was sufficient and unchallenged. Similarly, under the PHA, non-appearance by the respondent compels the court to make the order final, provided the complainant's affidavit shows a case of harassment. If your abuser opposes the granting of the final order, the court will consider the evidence. You will each have the opportunity to tell your side of the story. Both you and your abuser have the right to a fair hearing. Their right to a fair trial includes the opportunity to see and challenge the evidence against them. The courts strive to balance flexibility with fairness. The court can receive additional evidence to get the full picture, but must also give the other party an opportunity to rebut or comment on it. Evidence at the hearing can be presented through affidavits, documents, and/or oral testimony. Common evidence includes sworn statements by the parties and witnesses, text messages, emails, social media posts showing harassment, photographs of injuries or property damage, etc. You should be prepared to give oral evidence if the magistrate considers it necessary to resolve factual disputes. If the case hinges on a disputed fact, first-hand testimony is more persuasive. For example, rather than saying, "My neighbor told me she saw the respondent lurking outside my house," have the neighbor file a supporting affidavit or come to court to testify. At the final hearing, the court will assess all the evidence and decide whether it is more likely than not that the alleged domestic violence or harassment occurred. If your abuser provides a plausible counter story and you can't rebut with additional evidence or testimony, the court might not grant a final order. However, magistrates are also guided by the purpose of these acts to protect victims while ensuring fairness, and will not let overly technical objections defeat a worthy case. To maximize your chances of obtaining a final protection order, prepare your evidence thoroughly. Include detailed descriptions of the abuse or harassment, dates, places, what was said or done, and how it affected you. Use clear, factual language. Attach any tangible evidence such as printouts or screenshots of messages, photographs of injuries or damage, police case numbers if you have them, etc. If others were aware of the situation, ask them to write affidavits. Organize your evidence for the hearing. Bring originals of documents if possible. Prepare a chronology of events so that you can clearly explain the sequence of incidents. Anticipate what your abuser might say and be ready to address it. Be candid about any weaknesses in your case. My firm can help you with this if you're unsure. Domestic violence and harassment protection order hearings carry high stakes for both parties. Your safety and your abuser's freedom of action are on the line. South African law provides a framework that aims to be accessible, swift, fair, allowing courts to consider a broad range of evidence and conduct hearings with flexibility. The DVA and the PHA allow for allegations to be proven on a balance of probabilities. The court may act on incomplete information, initially to avert imminent harm, then test the evidence more fully at the return hearing. If you're involved in a DVA or PHA hearing, here's a reminder of what you should do. Know the procedure. An interim order is just the first step. A final hearing will determine longer-term relief. Understand your rights. The right to be heard, to present evidence, to question the other side, and to undergo a fair process. Prepare your evidence. Bring all relevant proof and be ready to substantiate your story under oath. Be truthful and complete. Credibility is key and full disclosure is required, especially for applicants seeking ex parte relief. Focus on what's relevant. Keep the evidence and testimony to the incidents of abuse or harassment and their impact, as that is what the court must ultimately base its decision on. You are entitled to represent yourself. However, if you would prefer not to go alone, I can provide legal advice and support. Get in touch with me and my team on the number below for help with any concerns you may have about abuse or harassment.